It is my pleasure to welcome you to this UIC Alumni Exchange program. The UIC Alumni Exchange series began in 2020 during the height of the pandemic to bring our alumni and friends programs and topics so you can explore and learn with the community of UIC alumni, staff, and faculty experts. A few quick housekeeping items before we get started. If you have any questions throughout, please submit them through the Zoom Q&A button, and we'll get to as many as we can. Please be aware this is being recorded, as you may have just heard, and you will also receive a 30-second survey after the presentation. Please let us know your thoughts. And with that, I'm excited to introduce you to today's UIC faculty expert. Stephen D. Schwinn is a professor of law at the University of Illinois Chicago School of Law. He teaches, writes, and speaks on topics related to constitutional law, politics, and public policy. He focuses on the intersection between the separation of powers and fundamental rights. Professor Schwinn's writings have appeared in a variety of law journals and popular press outlets. He regularly appears in the media and works frequently with organizations on civic education and civic engagement. Today, he joins us to explore topics and trends of the current administration and how these policies impact us and our constitutional system. Thank you so much, Professor Schwinn, for joining us today. I'll turn it over to you to begin.
Thanks so much, Emily Ann. I appreciate that warm introduction. I just want to do a quick sound check and make sure everybody can hear me.
Yes, you sound great on my end.
Awesome. If anybody has trouble hearing, I hope you'll drop a note in the Q&A. I have my eye on it, and Emily Ann and Damaris will as well. I want to first thank Emily Ann and Damaris and Karen and the whole team at Alumni Relations at UIC. This is a fabulous, fabulous, wonderful honor to be with you today, and I'm thrilled to be back. This is not my first round with the Alumni Exchange, and so I'm very, very happy to be back with you today. My name again is Steve Schwinn. I teach law, constitutional law in particular, at UIC Law. I've been teaching at UIC Law and before that John Marshall Law School, which you may know, then joined UIC for almost 20 years now. My areas are constitutional law, the separation of powers, international human rights, fundamental rights, First Amendment, and I look particularly at the intersection of separation of powers and individual rights in my writing and my speaking. These days, I've been talking a lot about what's going on in constitutional law and public policy, given the seismic changes that we're seeing. And I actually want to start there. I think the setup here is that we really are experiencing a constitutional moment. I think it's safe to say, like no other in our country's history. We certainly have had constitutional moments in our country's history. Over time, we've seen moments like, for example, the Civil War or the revolution in government in the 1930s, and some might even say the Reagan Revolution in the 1980s, and others might count other revolutions as well. This is a constitutional moment right aside some of those others. And I don't say that in a particularly partisan way. In fact, I hope I'm saying it in an entirely nonpartisan way. I think both Trump supporters and Trump opponents and anybody else who's paying attention to what's going on in politics and the news these days would agree that this is an extraordinary moment. We're seeing seismic changes in our separation of powers system and changes that are likely to last and endure for ages and generations to come. And I want to talk a little bit about that. What I'd like to share with you today is what I'm seeing as a longtime observer of the separation of powers in politics and public policy, what I'm seeing happening in our country today, and why it ought to worry you, or why you ought to celebrate it, depending on what your politics are, and what we can do about it or what we can't do about it. Again, depending on what your politics are, I think it's an important time for civic engagement and civil engagement, one way or the other. And I hope to share some thoughts with you about that today. Just a kind of administrative matter. I do have my eye on the Q&A, and I hope that you'll feel free to drop a question or comment in The alumni folks are helping us monitor that. So as we go through this today, I hope you'll feel free to participate and ask a question or drop a comment. And as always, I hope you'll engage with me anytime. You can always drop me an email at Schwinn, SCHWINN, at uic.edu, or connect with me on LinkedIn, or otherwise get in touch with me. I'd love to hear from you. So let's go ahead and get started. Where I thought I'd start is just some really basic kind of separation of powers things and describe to you kind of what I'm seeing at a 30,000-foot level, and then move into a couple of illustrations depending on how much time we have. And again, I want to leave plenty of time for interaction and discussion. I want to address the issues that you're concerned about. So, starting at 30,000 feet, we all know that our separation of powers system, we have three branches of government. We have a legislative branch in Congress that's covered in Article 1 of the Constitution. We have an executive branch, the presidency and the administrative state, that's covered in Article 2 of the Constitution. And then we have the judiciary, the court system headed by the Supreme Court, that's covered in Article 3 of the Constitution. Now, just a couple of things about these three branches of government. First off, they each have their own function. Under the Constitution, the legislative branch, Congress, is designed to make law, make public policy, and enact law. The Article 2 branch, the presidency, is designed to what we say execute the law or enforce the law. The Article 3 branch, the courts, decide what we call cases and controversies about the law. Cases and controversies are disputes that you and I might have, or other individuals might have, or individuals might have with the government, and bring them to court to help resolve those disputes. Now, those functions aren't exclusive. We know that there are checks and balances in our system. And just for an obvious example, we know that the presidency has agency in lawmaking because the president has the veto power under Article 2. And we see other checks and balances in our system that give what the framers called agency for each branch in the functions of the other. But it's important to understand that we have three different branches with three different functions. Now, because they have three different functions, they also have certain institutional competencies. So, for example, Congress is really, really good, or designed to be really, really good, at hearing evidence about public policy, making political decisions, and turning public policy and political decisions into law. The presidency is designed to be really good at enforcing the law. The president, as it turns out, is the only person who is the single head of a department of our government. Remember, Congress has 535 members. The courts have many, many members, but 9 of them on the Supreme Court sit at the top. It's only the presidency that has just one person at the top. And we'll return to that idea kind of later in this talk. But it's important to remember that, and important to remember, too, that the framers saw the president as vigorous and energetic. And that's why they put just one person at the top of that branch, so that we would have vigorous and energetic enforcement of our laws. And then Article 3, the courts are really, really good at hearing evidence in the context of individual disputes, individual cases. They're really, really good at testing that evidence through the rules of evidence and then rendering decisions based on individual cases. This individual case idea is something that we'll return to here in a few minutes as well. So each has institutional competencies and each has different lines of democratic accountability, right? Members of Congress are elected differently than the president. The judges aren't elected at all, but there is a measure of democratic accountability because they're nominated by the president with the advice and consent of the Senate. The president and the Senate both being elected, the judges have a kind of vicarious political accountability. And judges can be impeached, which gives them an additional kind of vicarious political accountability. So each of the three branches has its own functions, it does its own thing. Each of the three branches has a kind of institutional competence by design in order to do the things that the framers thought that they would be good at. And each of the three branches has a kind of democratic accountability that answers to the people, we the people, in different ways. What I thought I'd talk about today is what I'm kind of seeing in the relationship between these three branches in the present administration. Now, the framers designed the three branches so that there would be a kind of push and pull between the three of them. What the framers recognized is that anybody in power is going to seek more power. And so we build into the system a kind of checks and balances so that if any one branch starts to become too powerful, the other branches can push back. And the framers explicitly designed the system to operate this way. And so if Congress looks like it's becoming too powerful, the executive and the judiciary can push back. If the courts look like they're becoming too powerful, Congress and the executive can push back. And of course, if the president is becoming too powerful, by design, we look to Congress and the courts to push back. What I think we're seeing in this current constitutional moment is something that the framers really didn't foresee, and that is that the president would assert outsized power. Now, the framers did foresee that, but what they didn't foresee is that Congress and the courts wouldn't fully do their job in pushing back. And so, as a result, what we're seeing is a trend in the first few months of the second Trump administration where the courts and Congress are moving to aggrandize the power of the president themselves, that office, at the expense of the power of Congress, at the expense of the power of the lower federal courts, and at the expense of the power of federal agencies. And we'll talk about each of those as we go through this today. But what we're seeing is the Supreme Court and Congress kind of making decisions in a way or not making decisions in a way that's allowing the president to do things that really are not legal by most people's accounting. Now, at this point, I do want to drop a footnote. We're talking about the Trump administration, and it's impossible to talk about these things without sounding political. And I apologize about that. I don't want to sound political. So I'm going to tell you what I tell my students. When we think about public policy and politics and separation of powers, it's important to make your constitutional commitments about separation of powers. Do you want a powerful president, or do you want a powerful Congress, or do you want powerful courts? It's important to make those commitments without regard to who's in power. Now, what I mean by that is if you envision a strong presidency for a president of one political party, you need to recognize that you're also envisioning a strong presidency for a president of a different political party. And if we can apply that kind of thinking to our commitment to separation of powers and public policy and politics, I think that'll help us stay at least arm's length, or at least try to stay arm's length away from the politics. If you think, for example, as we'll talk about here in a second, that President Trump has the power to close down the Department of Education, an executive branch agency that's created by Congress, vested with power by Congress, and funded by Congress. If you think that President Trump has the power to close down the Department of Education, do you also think that President Biden has the power to do what many would consider a much more modest thing, and that is grant loan forgiveness that's administered by the Department of Education, right? And so testing your commitment kind of both ways will test your commitment to the separation of powers. Now, that said, one of the beauties of our system is that the separation of powers and federalism, all these structural aspects of our constitutional system, give us plenty of room to disagree about particular public policies and politics, plenty of room to do that within the bounds of the law. And so we can also use these things to make arguments. But I do want to caution you, when you make arguments, just be careful that the commitments that you're making as a constitutional matter are going to work both for your political allies and for your political foes. Because if it doesn't work that way, our entire system breaks down. Okay, with that caveat, what I thought we'd do is talk about three key areas to the extent we have time. We're going to get through as much of this as we can, three key areas that we've seen in the Trump administration in recent months that I think underscore these principles and kind of illustrate them for us. And again, if you have questions or comments as we're going through this, I hope you'll feel free to drop them into the Q&A. I'm keeping my eye on that. The alumni folks are keeping their eye on it as well, and we'll address as many of those questions as we can as we go through this. I'll also pause from time to time just to give you a chance to ask questions if you like. Let me tell you about these three key areas, and then I'll do one of those pauses. So, I want to talk to you about birthright citizenship. The birthright citizenship case that the Supreme Court ruled on last month is really, really important for a variety of different reasons. And I'd like to walk you through that and talk about some of the institutional implications of that case, as well as the birthright citizenship implications of that case. Second, I'd like to talk about how the President Trump administration, how President Trump in particular, has asserted control over the administrative agencies. And we'll kind of unpack that and talk about what it means. I mentioned a second ago the Department of Education. There are many other examples of this in the Trump administration. And it dovetails nicely with a theory that has been kind of building at the Supreme Court for the last 20, 30, 40 years. And we'll talk about that, called the unitary executive theory. And then finally, the third area that I thought we could talk about is immigration enforcement. We heard a lot about that in the early Trump administration. We're hearing about other things in the news today, but immigration enforcement is still important. And some of the things that we saw in the Trump administration illustrate some of the trends, in my view, that we talked about earlier. And we'll use those to sort of illustrate those trends as we go forward. Okay, so I'm just going to pause here for a second and ask if anybody has any questions or if there are any other particular topics that you'd really like me to touch on, and we can rejigger things accordingly.
Hi there, Professor Schwinn. Do you see the question
I
there?
do, and
Yeah, you read through it? Yeah.
what a fabulous question.
Yes.
Um, Okay, good. And another fabulous question as well. I'm going to take these one at a time, and if others come in, we can talk about those as well. I love this first question. I'm just going to read it aloud for everybody. Executive branch is either making laws or implementing rules, hoping to get sued to compliance. By the time we meander through the courts, what the executive branch will get away with what are now understood rules or laws. Congress looks like an accomplice, mainly because they have Congress in their pocket, the president, that is. No one wants to lose a job that allows rules or laws to be made. What do we, the people, do? What a fabulous and loaded question. So, I had talked a second ago about the different institutional designs of the three branches of government, and I talked about this sort of vigorous, energetic way that the framers designed the presidency. That's right from the Federalist Papers. What that means is that the presidency, the Article 2 branch, can act very quickly, can act very decisively, and can act aggressively in ways that we've seen the Trump administration, and many would argue earlier administrations as well, the way that we've seen the Trump administration act in the first months of the second Trump presidency. But here's the thing, if we're looking for pushback by the courts and by Congress, the framers didn't design those institutions with the same sort of energy and vigor that they designed the presidency. In fact, they designed the courts and Congress to be very slow, deliberative bodies that work over a period of time, not with the kind of energy and vigor that the president operates with. And indeed, both Congress and the courts have very, very few tools, really only extraordinary tools, to act very quickly in the wake of a situation, whatever that situation is. Now, when you sort of put those pieces together, what that means is that the president can act very quickly and decisively, even in violation of law, without getting significant pushback from the courts or Congress, or at least a kind of delayed pushback from the courts or Congress. And I think what the questioner may be suggesting here is that in the meantime, the president could continue to violate the law, for example. And that's true. That's by institutional design. And we'll talk about how the Supreme Court has responded to that in these three cases that I mentioned, these three situations that I mentioned. But the question is really insightful. So, what do we do about it? Well, I think there are a lot of things that we can do about it. Um, and, I think having talks like this is really the first step. I'm really committed to civic engagement, to civil dialogue, talking to each other, persuading each other, and working problems out and working our own ideas into the public discourse. So if we have a particular feeling about a presidential action versus congressional inaction or the court's inaction, for example, we can talk about it more, talk about it to our families, friends, community, and try to persuade them. And we can get involved through organizations and civil society. There are other things that we can do too that we'll talk about kind of as we go through this presentation. But the what we can do about it question, I think, is really, really key. And I do want to come back around and talk about that. So I hope the questioner will pull me back and remind me if we don't get there. Another question, what can you say about what UIC has done to respond to the directives from the current administration? How have UIC students been impacted by these directives? Well, there's a lot of stuff going on with the administration that touches on higher education. So you might have read, for example, about immigration enforcement, which I had mentioned earlier, and that's going to touch student population at a place like UIC, where we have a lot of international students, as do many other institutions. And so we are considering issues of immigration enforcement with our international student population and how to respond to that. The other big front that UIC is confronting, along with many, many other institutions, is cutbacks in research funding. University of Illinois Chicago, you may or may not know, receives quite a bit of money from the federal government to support its federal research projects that do all kinds of wonderful things for science. The administration has pulled back on much of that funding for a variety of different reasons from different institutions around the country. Northwestern has been particularly hit in the Chicagoland area. I'm happy to report that so far we've seen not huge hits at UIC, but we are preparing for what might happen if bigger hits come to the university. And so the UIC has thankfully not been a target in the same way that schools like Harvard have, or Northwestern, for example, or some other schools that we're reading about in the newspaper. But like every school around the country, UIC is preparing as well. Um, Typing questions is difficult. Yes, I appreciate that. It is, and I'm sorry. Trump is stepping on the first, fourth, fifth, 12th, 14th, and 22nd Amendments. Yeah, that's a mouthful. So there are different Trump administration actions that, and we'll talk about some of them today, that do seem to be violating different constitutional provisions. And we'll talk about how Congress and the courts have responded or not responded, how the states have played a role in all this, and again, how civil society plays such an important role in enforcing our amendments. Waging war, dropping bunker busting bombs without consultation, let alone declaration of war. Again, a lot packed into that question. We know the Trump administration has taken military action without the express consent of Congress. That is a declaration of war. We know that Congress and the president share the war powers. Recent presidencies of both parties have taken liberties with the president's commander in chief authority and have initiated and continued military action without the kind of express consent of Congress that the framers may have envisioned. This is something that we kind of come to a sort of bipartisan consensus on, that Congress seems to be playing less and less of a role in these kinds of matters. There is some legislation on the books that attempts to control the president and rein the president in when the president takes unilateral military action without express congressional authorization. But there's some dispute. Presidents routinely say that that legislation is itself unconstitutional. And so there is this kind of give and take between Congress and the presidency around war powers and how the president can prosecute war powers. The courts often don't get involved in those cases. They sometimes do, but they often don't get involved in the core question of presidential authority to use military force because they consider that what we call a political question that is beyond the institutional expertise of the federal courts. That's a really good question. Will a change in Congress in 2026 put the separation of powers back in balance? That's a really good question. Um, if there's a change in Congress, and you may note what's going on in Texas with redistricting right now, and a number of other states, including Illinois, are considering redistricting efforts mid-census, which is highly unusual, not illegal, but highly unusual, in order to figure a way to get more seats of their preferred political party in the House of Representatives. Many people think that the 2026 elections could mark a change in control of the House of Representatives, depending on what happens with this gerrymandering effort in different states. But many commentators don't see the Senate turning over. Even if both the House and the Senate turned to Democrats in the 2026 election, remember that Congress's powers here are going to be somewhat limited against a president who is by design vigorous and energetic. And what we saw in the first Trump administration, even when Democrats were in Congress, were in control in Congress, we saw a Trump administration that was effectively evading checks on the presidency that Congress has. And so the big ones here are Congress can hold oversight hearings, Congress can withhold funding from preferred presidential initiatives. Congress can hold up appointments of the executive branch in an attempt to control the president. And ultimately, of course, Congress can move to impeach the president. What we saw is each of those levers of checks and balances in the first Trump administration, they weren't particularly effectual against a presidency that, again, by design, is vigorous and energetic. What we're seeing so far in the Trump administration is almost kind of um, studied learning from what occurred in the first Trump administration and moving even with more vigor and energy, again, by design, against controls in Congress. And so, even if the Democrats were to take over Congress, and again, to be nonpartisan about this, we could say if it were a Democrat in the presidency, we're talking about Republicans taking control in the midterms. It may or may not fully restore the balance of powers. We'll just have to see. And we do have a Supreme Court these days that is tilting more and more toward the power of the presidency in different ways that we can talk about. And so the Supreme Court may not be doing its check either. Uncontested anti-Semitism violations of Title VI of the Civil Rights Act were not acted upon by President Biden, but are being contended by the Trump administration. That said, arguments of violations of the First Amendment right is claimed as breaks upon targets against Jews. Are there not restrictions to entitlements if free speech and assembly? Yeah, good point. There are free speech issues involved in that debate. And in the academic context, there are also academic freedom issues involved in that debate. And I think the questioner here raises a good point. You know, if we are expecting one thing from one administration in terms of the way the laws operate in our separation of powers system, it's always a good question to ask if we would expect the same thing from a different administration, and see how that administration would enforce the laws and what sort of checks and balances follow from that. Do you anticipate the long-term effects of the Trump administration will be on the ways in which our government functions? Good question. So there are two things that I have my eye on. One is what I teach my students just as judicial precedent, right? So to the extent that the Supreme Court is ruling to aggrandize the power of the presidency, those rulings will have staying power for years, decades, even generations, depending on how long the Supreme Court goes without overturning them. The way the court is currently composed, that could be a long, long time. Now, the thing about the Supreme Court rulings aggrandizing the power of the presidency, again, it's going to operate both ways. And so when a Democrat regains the White House, as they inevitably will, at some point, they're going to inherit the power that the Supreme Court has given to President Trump. And so, again, this is a good point to test our commitments on separation of powers. Do we like an aggrandized power of the presidency? Or do we not like it? And that may depend on who's in office. Well, if it depends on who's in office, maybe we ought to rethink how we commit to the powers of the presidency. So, one thing I think about is Supreme Court precedent. The other thing I think about is a little more subtle. It's what I teach my students as practice as precedent. In our separation of powers system, the way the three branches operate in relation to each other always sets a kind of precedent for how they're going to operate in the future. And so, for example, if the president does such and such without significant pushback from Congress or the courts, what that's telegraphing to future presidents is that they too can do such and such, or maybe even more, or in a different way, without significant pushback from Congress or the courts. Or if Congress does such and such, and the courts and the president don't significantly push back on it, that sets a kind of practice as precedent for future congressional actions that may be of the same kind or different or more aggressive or what have you. And so the practice as precedent that we're setting between the three branches, I think, is a really important thing to keep our eye on these days. And again, the current composition of Congress and the Supreme Court and the White House, they're going to change over time. Our country has a tendency to kind of ebb and flow, move back and forth like a pendulum. These things are going to change at some point. And what we ought to be asking ourselves is, are we going to be happy with the way things are operating today when different political actors are occupying those offices? Do you have any advice for institutions and citizens who want to continue to protect their communities without dangerous pushback? How do we balance safety and taking a stand? Really good question. um, a question that a lot of folks that I talk to ask. There are a lot of different ways to get involved. Again, just having discussions like this, I think, is a really important way to stay on top of issues and engage each other and engage in civil, civic dialogue about these issues and try to persuade each other that our preferred way of organizing our government or enacting public policy is the right way, because after all, that's what a democracy is all about. Getting involved in civil society and civic organizations, I also feel very passionately about. And as we kind of move through this today, I'll share some more specific ideas with you about how we can do that. And there are other ways to get involved, right? I mean, the obvious levers of impact in a democracy are things like the vote or the voice or contacting your representatives in the state legislature or Congress or even at city council or the school board. And those are important levers, but they're not the only ones. And I'll share some more as we move through this today. Question for the end. The Trump administration appears to be pressuring various segments of society to conform to the president's wishes, including law firms, media companies, federal administrators, and universities. What distinguishes the institutions that have most successfully resisted this trend? Ooh, good question. Hmm. It's not clear to me, quite frankly, that there is a distinguishing feature. We've seen different law firms, different universities, and different institutions either adhere to demands from the Trump administration or not. And it's not clear to me that there's a particular pattern in the feature of the institutions that are either adhering or not to demands of the Trump administration? That's a really good question. I'll have to give a little bit more thought to that. Um, but off the top, I haven't seen any clear patterns that have emerged. So please comment on Supreme Court tenure. Wow, you all just have fabulous, fabulous questions. I hope it's okay with everybody that I continue to address your questions, um, because these are really, really good. Please comment on Supreme Court tenure. It's often said terms are for life, but the Constitution says during good behavior. Yeah, that's exactly right. And I had mentioned earlier that judges can be impeached. We do have life tenure for 9 justices on the Supreme Court right now, but there's nothing in the Constitution that says that there have to be 9. And there's nothing in the Constitution that says that they have to serve in the Supreme Court for their entire tenure in the way they're currently comprised. And so, for example, different folks have toyed around with the idea of a rotating panels at the Supreme Court, which some other constitutional democracies do in their high constitutional courts, so that you're not always dealing with the same nine. You may be dealing with different compositions of judges on the Supreme Court, or rotating judges off the Supreme Court onto lower federal courts where they're still judges, still serving for good behavior, but not on the Supreme Court, and get a greater diversity of views on the Supreme Court. I am not crossing my fingers for any Supreme Court reform anytime soon, regardless of who controls which branches of government. And the reason that I say that is the Supreme Court itself has become so politicized in the last, well, it's always been politicized, but it seems hyper politicized these days. And any move to change the Supreme Court is going to be seen through a partisan lens. I'm just not sure that either party is going to be able to come up with the votes that it needs to make that kind of change to the court, given our current politics. Um, I see a question about state or local pushback, a question about for anyone in the less government interference camp. Is this not the administration with the most government interference? Okay, good. Um, it seems okay to eliminate the Department of Education for the purpose of government efficiency. Isn't it Congress that does that? Yep, good. And free speech restrictions. Um, is it ever slander or libel? Uh, or inferred violence promotion ever permissible under our Constitution? Well, so I'm going to address that one real quick. Slander, libel, and violence, advocacy of violence are all very technical terms in free speech jurisprudence, and they're strictly speaking, they're not allowed in the sense that there are civil damages for libel and slander, and sometimes even criminal damages for incitement of riots or insurrection, that kind of thing. But the definitions of those terms are very narrow, and in public discourse we tend to use them a little bit more broadly than the law uses them. I'm going to go ahead and try to address some of these questions through the three areas that I talked about, or at least through the birthright citizenship case, which I think actually does a really nice job of addressing many of these areas. And there's a question about Department of Education, so I do want to touch very briefly, if we have time, on the president's control over the administrative state. But let's start with birthright citizenship and kind of unpack this case. Now here, I want to go back to the 14th Amendment and what President Trump did in the executive order with regard to birthright citizenship. So the 14th Amendment says that all persons born in the United States and subject to the jurisdiction thereof, are citizens of the United States. The Supreme Court validated what many would consider to be the plain meaning of that clause in an 1898 case called Wong Kim Ark. Wong Kim Ark. Now, Wong Kim Ark was an individual born in California to two parents who were Chinese nationals. They were not US citizens, they were Chinese nationals. Wong Kim Ark was born to these parents in the United States in California. He traveled back to China at one point to visit family, and when he tried to return to the United States, immigration officials said, "You can't come in, you're not a citizen." He challenged that all the way to the Supreme Court under the 14th Amendment Birthright Citizenship Clause. And the Supreme Court said, "Yep, that's right. You are a citizen. You were born in the United States. You're subject to the jurisdiction thereof." And remember, his parents were not US citizens, and he was not a US citizen except for birthright citizenship. The Supreme Court said, "You have birthright citizenship." In the mid 20th century, then, Congress enacted legislation that mirrors the language of the Birthright Citizenship Clause in the 14th Amendment. It's exactly the same, validating Wong Kim Ark, the 14th Amendment itself, and the commonly understood meaning of that phrase that if you're born in the United States, you're a citizen of the United States. Now, just one quick beat on that phrase, subject to the jurisdiction thereof. What this would exclude, for example, is diplomats who are visiting the United States temporarily and may have children in the United States. Under common understanding, diplomats who have children in the United States are not giving birth to a citizen of the United States under the Birthright Citizenship Clause. Or, for example, if there were an invading army coming into the United States, an actual invading army coming into the United States, and the soldiers had children in the United States, under a common understanding, those children would not have birthright citizenship because they're not subject to the jurisdiction thereof. But those are very, very limited, extraordinary exceptions. In the ordinary course of things, when somebody like Wong Kim Ark is born in the United States, they're a United States citizen. And that's been our common understanding ever since the 14th Amendment was adopted, affirmed in Wong Kim Ark, and affirmed in the mid 20th century by Congress. Donald Trump, when he came into the presidency, one of the first things that he did was purport to revoke birthright citizenship by redefining our common understanding. What he said was, subject to the jurisdiction thereof doesn't mean what we have customarily thought it meant. What it means is that if a person's parents don't owe allegiance, primary allegiance to the United States, they instead owe primary allegiance to another country because they're citizens of another country, then their child is not a citizen under the Birthright Citizenship Clause. That child doesn't owe allegiance to the United States because their parents didn't. Their parents owed allegiance to another country where they were citizens. The Trump administration said that they were going to enforce this definition of birthright citizenship and move swiftly to deport anybody who purported to have birthright citizenship, but whose parents were not U.S. citizens. A group of states sued, individuals sued, people that were pregnant that would give birth to an otherwise birthright citizen, and organizations sued, and courts uniformly issued injunctions halting the Trump administration from enforcing that executive order. Now, the kind of injunctions that they issued were what we call universal injunctions or nationwide injunctions. And what the court said was the Trump administration can't enforce this executive order anywhere in the United States. Now, that's a little unusual in our legal system. More usually in our legal system, what happens is a court would issue an order with regard to the parties before it. And so, for example, if you sue me as my neighbor because I'm playing my music too loud, the court can order me to turn my music down, and that benefits you, my neighbor. Now, it may incidentally benefit another neighbor who didn't sue me, right? But that other neighbor can't run back to court to enforce the court order if I go and play my music loud again. Only you can. And so the idea is that the courts are limited in the way that they rule on cases to the parties before them. And therefore, this idea of universal injunction or nationwide injunction that would apply across the entire country has been controversial for a long, long time. The Biden administration asked the Supreme Court several times to take up a case involving universal injunctions and to rule that universal injunctions exceeded the powers of the federal courts. The Supreme Court declined. But in the Trump administration, the Supreme Court took up this challenge. The Trump administration argued to the Supreme Court nothing to do with birthright citizenship, but that the lower court's universal injunctions exceeded the power of the lower federal courts. And what that meant was the lower federal courts didn't have the power to issue universal injunctions. The Supreme Court, in a ruling late last month, ruled that that's right, that the lower courts don't have the power to issue nationwide injunctions, and that these courts who issued nationwide injunctions against the executive order changing the definition of birthright citizenship, well, they don't have the power to do that. They only have the power to grant relief, injunctive relief, an injunction as to the parties who actually brought the case. Now, what the Supreme Court said was there may be some exceptions to this. And so, for example, if the parties can file a class action, then a court might be able to certify a class nationwide and grant universal nationwide relief or an injunction. Or if the states sue, in some instances, the states will have such an interest in the case that the courts have to grant nationwide relief in order to grant particular relief to a particular state. And I'll say more about that here in a second. And then there was a final technical way that the federal courts can grant nationwide relief that is coming up in some other cases, but I'm not going to bore you with that just in the interest of time. Now, what the ruling left open is then the possibility that the Trump administration could enforce the birthright citizenship executive order on a person by person basis against anybody in the country who hadn't yet sued the Trump administration. And even if courts were routinely saying that the Trump administration can't enforce the birthright citizenship executive order against plaintiffs in these cases, well, the Trump administration still could enforce the birthright citizenship executive order against other individuals who had not brought suit. And so, what the effect of the ruling was to allow the Trump administration to continue to enforce the executive order on a person by person basis as long as it wanted to until it effectively exhausted all the people that it wanted to enforce it against in the United States who hadn't yet sued. Well, more recently, what happened in the lower federal courts is that states argued, our interest is such that you federal courts, you really have to grant nationwide relief. And some federal courts have started now to certify nationwide classes of individuals who may have a child who would get birthright citizenship, but for President Trump's executive order. And so, through the class action device and through state lawsuits, we are now seeing universal nationwide injunctions issued by the lower federal courts so that the Trump administration is prohibited from enforcing its executive order anywhere in the country. I mentioned a second ago just about states. So it turns out Illinois is one of these states who brought suit. What the states have argued is that the birthright citizenship order is going to harm them because they administer programs like Medicaid, right? A federal state program that provides medical services, health insurance to low income individuals. But the thing is that non citizens generally don't qualify for Medicaid. And so for a state like Illinois, they constantly have to make decisions about who's a citizen or who's not a citizen in order to qualify for Medicaid. Well, if President Trump's executive order were to go into effect in only parts of the country, but not the entire country, that would put a state like Illinois in quite a bind because a person born in a state like, say, Indiana, where President Trump's executive order might stay in effect, might travel to a different state, like, say, California, where President Trump's order might not be in effect. And so then the states would have to say, well, did the person come from a state where there was no birthright citizenship? And if they move to a state where there is birthright citizenship, do they become a citizen? How do we sort all this out? And what the courts so far have said is, look, we understand that's a problem. It's a nationwide problem. And so we'll grant universal nationwide relief. Now, these cases will inevitably go back to the Supreme Court on two questions. One question will be, can the courts grant universal nationwide relief to a certified class or to states? A kind of technical question that the Supreme Court will have to answer. The second question is the Trump administration's interpretation of the 14th Amendment Birthright Citizenship Clause, is that right against Wong Kim Ark and our country's entire history since the 14th Amendment of understanding that birthright citizenship means if you're born here, You're a citizen here, even if your parents aren't citizens. Now, those two questions will go back to the Supreme Court, maybe next term, maybe the term after. In the meantime, if the Trump administration adheres to the lower federal court orders, it will not enforce birthright citizenship or its version of birthright citizenship anywhere in the country. But given the Trump administration's history with the courts, some people think that's an open question whether the Trump administration will comply in the meantime. And so that's kind of where we are with birthright citizenship. And through that example, I hope you can see that what's going on here is the Congress and the courts are seeming to not push back against an extraordinary assertion of executive authority on the part of the president. And in that way, aggrandizing the power of the presidency as an office, no matter who's in the office, at the expense of Congress, who, remember, enacted legislation in the middle 20th century that mirrored the 14th Amendment, and the courts, who, remember, tried to issue nationwide injunctions against the president, but the Supreme Court said, no, you can't do that. So we'll see where this case goes and what's going to happen in terms of public policy and immigration enforcement. But this is my first example of the Congress and the courts not pushing back against aggressive executive authority and in that way aggrandizing the power of the presidency. I see a ton of questions have come in. And I'm going to apologize in advance. I'm not just not going to be able to get to all of these. These are fabulous, fabulous questions. Thank you. And I think what I'm going to do is um, a oh, these are really good questions. Thank you all. Um, I want to, okay, these are fabulous questions. And if I'm not answering your question either directly or indirectly, I hope that you'll email me and follow up with me. I'd be happy to engage with you. Again, Schwinn, SCHWINN at UIC.edu. I do want to talk very briefly about a case and a couple of cases actually that we saw from the Supreme Court with regard to presidential control over the administrative state and just talk about what's going on there, and then offer just a few closing comments about what we can do about all this if we're inclined. So the Trump administration campaigned on and then ultimately moved to close down the U.S. Department of Education. U.S. Department of Education is a cabinet level agency that Congress created in the 1970s. Congress vested specifically with statutory authority, and it gave it a whole mess of money to go ahead and do its job, which includes a lot of really important things that you and I count on, like offering and collecting on federal student loans so that we can go to school, for example. The Trump administration moved to close it down by reduction in force, by riffing about half of the workforce at the Department of Education, and then outsourcing some of the key functions to other agencies. Well, the problem with this is that civil service laws prohibit this kind of massive dismantling of a federal agency. Laws governing the Department of Education restrict the president in moving some of these functions to other agencies. And you can't, as president, just go fire everybody. It just doesn't work that way. When Congress has vested an agency with authority, given it money, and specified certain offices and functions that that agency must fulfill. So the lower federal courts issued injunctions against the Trump administration saying, you can't do this. You can't dismantle the Department of Education. The case went to the United States Supreme Court, and the Supreme Court, in a ruling on its emergency docket, that means without full briefing, without oral argument that it gives in any normal case, the Supreme Court ruled without explanation that the Trump administration could continue dismantling the Department of Education pending the outcome of the underlying litigation. Now, what that means is the underlying case is moving forward in the lower courts, but in the meantime, the Supreme Court has allowed the Trump administration to dismantle the department. Again, a department that Congress created, vested with authority, and funded. Pretty extraordinary. In fact, we've never seen anything like that happen in our country's history. And so the Trump administration will continue to dismantle the Department of Education while the case is pending in the lower courts. And even if the courts ultimately rule against the Trump administration, the department will have been dismantled. Going to one of the points that one of you raised earlier in our discussion about the damage that the Trump administration or any president can do, given the vigor and energy of that office that the framers designed in the office of the presidency, because of the slow moving courts in Congress to respond to them. And in this case, because of a court that's inclined to agree with the president, although not explain its reasoning, and so we don't know why, and a Congress who seems willing to allow the president to dismantle the federal agency, even if that goes against federal law that's on the books. We saw the president move against some key independent agencies in the first months of the Trump presidency. These cases went to the Supreme Court as well. And so the president unilaterally moved without explanation members of the National Labor Relations Board, members of the Merit Systems Protection Board, which is the board, incidentally, that is designed to protect civil service employees from getting fired. And so dismantling the Merit Systems Protection Board has a kind of double effect, aggrandizing the power of the presidency in relation to the civil service. And then members of the Consumer Protection Agency. These are independent bodies. The Supreme Court has long been on a move to embed this kind of unitary executive theory into constitutional law. And I think in these cases, it's right on the cusp of doing that, ruled for the president and allowed the president to remove these officers pending the outcome of the lower federal courts. But again, the president has removed the officers, even if the courts ultimately rule for the officers, they'll have been removed, and reconstructing those agencies will be extraordinarily difficult. Let me just say a couple of words about what we can do. There were really good questions about this. We can have discussions like this. I've already mentioned that. We can use our voice. We have free speech in this country, and we can use our voice to contact our elected representatives. That's an obvious point of influence in a democracy. A right to vote, too. But we can do more than that. We can get involved in civil society organizations that are working on one side of the aisle or the other, or in a neutral way to promote good governance or separation of powers values, or any of the constitutional values that you've raised over the course of this discussion. And I would urge you to look to civil society and find organizations that you can get involved with, that you can support with financial contributions or with time or with your expertise, and to get involved and try to persuade things to move in the direction that you want them to move, whatever direction that is. You know, we've come to a place in our constitutional democracy, a singular place in our constitutional democracy over the last decades that wasn't by accident at all. Much of this move has been a slow creep, step by step, by passionate individuals in civil society who have been moving the government in a particular direction and now have seen the opportunity to kind of see that come to full fruition. Now, those individuals have worked in civil society. They've worked in discussions just like this. They've contributed their time and their treasure to various organizations that will make that happen over the course of 20, 30, 40 years. My message to you is, if they can do it, we can too. Get involved in whatever side of the aisle you prefer. Get involved and stay involved and make the kind of constitutional change that you want to see in this world. I'm going to wrap it up there. It looks like we're just about time. Again, I invite you to follow up with me. I know I didn't get to a lot of your questions. They really are fabulous questions. And so please email me or contact me on LinkedIn. I'd love to hear from you.
Thank you so much, Professor Schwinn, for this incredibly interesting and timely presentation. We so appreciate you sharing your knowledge and expertise about everything and answering everyone's questions. I I know I've learned a lot, and I just really appreciate the time that you've taken today. And thank you to everyone who has joined us for today's program. If you are in the DC area by chance, or the DMV, I've been there before, please save the date of October 21st. We invite you to join us for a reception and a conversation with Professor Schwinn as we take UIC on the road with a stop in DC. If you would like to participate in future events like this, or volunteer with the UIC Alumni Association, or just reconnect with UIC, we encourage you to visit go.uic.edu/alumni for more information. And we look forward to seeing everyone again at a future UIC Alumni Association program. Thank you all so much and have a great day.
Thanks, everybody.